Well, thank you for coming and joining this update. This is our 2024 Spring Training General Government Update. We will be talking about quite a bit here. And if you've got any questions, I believe you can submit those questions, or if not, we can address those. We are going to be talking about quite a bit here. Let's see if I can work this. Quite a bit here. Locker rooms, money, prayers, retirement, and drugs. So we're covering quite the gambit here of the general government during this training. The first thing that we'd like to go over is finance and budget bills. And we start off with SB 91. This was Senator Chris Wilson and Representative Paul Cutler. What this does is anytime a city or town manager or chief administrative officer, city or town attorney, or any of the department or division heads receive a compensation increase, and we'll go over what that means. But anytime these individuals receive a compensation increase, there will need to be a standalone independent public hearing. And what that means is essentially that you will need to gavel out of any public hearings that you're currently in, and then gavel back into a public hearing solely for the purpose of hearing any compensation increases. This does not affect any of the elected officials' salary or compensation. By compensation, we're talking about salary, including salary paid under contract, budgeted bonuses, vehicle allowance, deferred salary. This would also include arguably citywide COLA increases, because they would be a salary increase. And then there's noticing requirements with that public hearing as well. The hearing would only need to be held once or twice per year, and it would allow flexibility for when you are making counteroffers to valuable employees or retention bonuses to be able to keep people employed with your city or town. Currently under the bill, it does not require any sort of particular format to show on that on the agenda or on the public hearing, just that it needs to be show what that compensation increase is. So what I mean by that is that you can show that compensation increase in a percent increase, a dollar amount increase, listing old compensation number and new compensation number. All would seem to suffice under the requirements under this law. It arguably does not apply to someone that is initially hired or promoted into an executive municipal officer position, because of an executive municipal officer's compensation is not being increased, is just being initially set. So, so if you got any questions, please send them our way, and we can see if we can answer those for you. The next one is SB 86. This relates to local government bonds amendments. This is only for lease revenue bonds, which, if you know them, they're not secured by taxpayer dollars. In other words, it doesn't need to go to a vote of the people for any increase, but it's secured by the facility being leased to the city. Most cities do this through a municipal building authority to accomplish the structure of the bond. The lease payments are then planned and approved in the budget each year to be able to meet those lease payments moving forward from year to year. What this bill does is it limits the amount of lease revenue bonds that can be the amount of the dollar amount of the bond, not how many times you can do a lease revenue bond, but over a 3-year period, it can exceed $200 million. So plan accordingly. If you've got projects coming up, you'll need to make sure that over the next 3 years, that if you are going to do lease revenue bonds, that those are all going to come to less than 200 million. So that is the cap. There are a few requirements for the public hearing there. And then as far as noticing, generally speaking, this is the same as other public hearings, but this is different. You would need to make a statement in a public meeting at least 14 days before the public hearing with the intent to issue, why you're issuing it, and the purpose and estimated amount behind the bond. And you'll need to include that also in the public meeting agenda as a separate item. And then there's different requirements as to what the statement actually must say. And you'll see those right there, statement of intent, et cetera, et cetera. So I don't want to spend too much time on the details. We've got a lot to go over. So if you do have any questions on any of these, please let us know and we can get back with you. I am going to let Liam take over on this one, HB 335.
Awesome. Thanks, Jared. Yeah, HB 335 state grant process amendments. This ended in a much different place from where it started. The original version of this bill precluded any local governments from receiving state funds, in fact. So we worked through that with GOPB and through some other partners to get that language fixed and amended, and Representative Peterson was very good about working with us on that. So what it does now is a few different things. Creates reporting and process requirements for state granted funds, meaning there are different requirements now of when you will receive your money or disbursements of any of the grant funds, as well as just different timelines of when you have to submit things in order to receive those funds. You have to propose a budget and deliverables prior to receiving the grant. So they want to ensure that what this grant is going for, that it will be used for the intent of the grant. So you have to submit your budget and sort of a plan of how you're going to spend those dollars instead of how some of them may work now. And then, like I mentioned earlier, state funds must be dispersed on a schedule that provides accountability and responsible oversight for the use of funds. This saying that, prior to receiving sometimes those end funds, you might have something like 80% and 20% at the end. Prior to receiving that 20% at the end, you need to submit a report that's showing that you're doing what you're supposed to be doing and meeting different deadlines that are required. The multi-year state grants may no longer exceed 5 years. So this is just putting some accountability on those longer grants and a review of those and possible renewal at another time. We're still working through exactly what that means or what that may entail for those longer grants, such as like what might be required of the organizations that are receiving the grants. So we will keep everyone up to date on that, but that was a new provision in there. Clarifies that the legislative auditor may review all state grant funds and then provides additional guidance and requirements for state agencies. These are different things like clarifying differences between direct awarded grants and then competitive grants. Some other provisions like not allowing a competitive grant to be awarded if that same organization that's receiving it has received a direct award grant for substantially the same purpose. So those are just some changes with 335. We got it to a much better place than where it originally started for us and for all the other local governments, MPOs and so forth. So we're thankful for that work, and we'll be updating that. And GOPB, I know, is now going to go through, as well as the other state agencies, and review their grants and be updating any contracts that they need to. So if you have any grants like that, whether they are single year or multi-year grants, look out for some communication from those state agencies. And then the effective date, they did do a special effective date of July 1st for the new fiscal year. So we won't have to worry about anything in this fiscal year.
Thank you, Liam. I see there's a question, contract attorneys, question mark. Not sure what that means, but
Yeah, so I saw that earlier. That was back on SB 91. They were curious if that was pertaining to contract attorneys. I'm assuming when they're talking about having to notice anything.
that would not be the, let's see. Good question. We'll get back to you on that. It went back and forth on that, and it involved the definition of who was involved and who was going to be required under this law went back and forth on this. And currently, right now, I think the bill just says that it is city or town attorney. It does not say contract attorney, which would be under a contract. So I'm sorry. That as far as the salary goes, it does say including salary paid under contract. So I'm mistaken. So that would, if you're paying under contract a certain amount, and that is their salary, then yes, that would apply. But I can check just to make sure, because I think that I'll get back to you on those specifics for your specific city on what we're looking at and see what we can find. So the next let's see if I can get there. Maybe. Okay, so the next topic is religion. There are 3 bills that were passed, HB 396, SB 150, and HB 460. Before I begin on any of these, I just want to make clear that this is a overview and not a comprehensive analysis. We are going to be coming out with a white paper of some sort that discusses these 3 bills. There is a big difference that you'll see in each of these bills in relation to the standards that are required, who it applies to, and what it addresses. And so we're going to start with this one, HB 396, Workplace Discrimination Amendments. This essentially just talks about workplace discrimination. It applies to not just governmental entities, but to all entities, except when we're talking about, there's some exceptions for those that have 15 or less employees that we will get to here. What it prohibits is compelling an employee to engage in religiously objectionable expression that the employee reasonably believes would burden or offend the employee's sincerely held religious beliefs. And that expression means action or inaction. Part of those examples, dress and grooming, speech, prayer, scheduling. So essentially, if someone has a religious ceremony on Saturday or Sunday or any other day, that is one of their sincerely held religious beliefs, that the government or any other employer cannot discriminate against that employee and must accommodate that employee, so long as, and here's the exceptions, if doing so would cause an undue burden to the employer by substantially interfering with the employer's core mission or the employer's ability to conduct business in an effective or financially reasonable manner, or the ability to provide training and safety instruction for the job. So those would be your exception if it's a struggle to continue business, and to if your ability to conduct business in an effective and financially reasonable manner. Just so you know, this is a different limited standard than what is in other bills as far as this exception is concerned. And we'll go over those exceptions, but this is a different exception. So be aware as you're applying these different laws, these three different laws, as well as the First Amendment, as well as the Utah Anti-Discrimination Act, all of which relate to all of these subjects of religion. So be aware of that. My first overriding piece of advice would be talk to your attorney if you have one, and decide how your city is going to handle and interpret each of these laws, especially meshing them together, and what you need to do for your HR office to make sure you're complying. There is a scheduling exception. Those that don't have 15 employees, less than 15 employees do not have to accommodate scheduling requests. So that is HB 396. The next one is SB 150. This was Senator Todd Weiler and Representative Jordan Tusher. The overarching goal here was to prohibit from inhibiting the free exercise of religion. Some of you may be saying, well, isn't that already included under the protections under the First Amendment? Yes, it is. So there's overlap between all of these. The exercise of religion is the right to act or refuse to act in a manner substantially motivated by a sincerely held religious belief, regardless of whether the exercise is compulsory or central to a larger system of religious belief. This exception is that you can inhibit the free exercise of religion if it would substantially burden, if it goes to the essential, it is essential to a compelling government interest and is the least restrictive means in furthering that interest. So if you qualify, if you hit both of those, if you think that there is a compelling government interest and that you have narrowly tailored that to just that specific instance, then I think you're going to be okay. Now, word of the wise here, it's very, very difficult under case law, at least, to meet those objectives. That something, whatever it may be, that inhibiting the free exercise of religion is almost never going to be a compelling government interest. It's very difficult to meet that standard. If that exercise of religion is taken to court and the city or town loses, the attorney's fees are going to be awarded to the prevailing party. So you should be aware of that as well. The next bill is a little bit more detailed than that, and it has quite a bit more exceptions, and so this one talks about prohibiting from denying an employee's reasonable request to be relieved from performing a certain job, duty, or function if that task would conflict with the employee's sincerely held religious beliefs or conscience. So this adds on the word conscience. The reasoning behind that was that so that if there is someone that is not religious but still has sincerely held beliefs that would rise to the level of religious beliefs, even though they may not be religious, that would qualify as well if it would conflict with the employee's conscience. There are quite a few requirements for employees to make this request. We're not going to go into those, but you need to be aware that there are different timelines and schedules that employees need to make before they make that request. It also prohibits taking retaliatory action if it is a meritorious request. The any of the requests that are made in writing or the responses made in writing to the employee are protected under GRAMA and subject to the same disclosure and penalty provisions under GRAMA. So the exception here, though, like I said, is far broader than either SB 150 or SB 396, HB 396, sorry, and takes into account a lot more factors when looking at whether this would be an undue burden or an undue hardship on the governmental entity. So just be aware that looking at it in context with all circumstances that the government entity is operating in. So, for example, a big city is not going to be the same as a small city that does not have the same staff sizes, the same ability to respond to a scheduling request, or hey, I can't do this because I have a religious ceremony on this day. It's going to look very different from one city to the next. So this takes into account all of the relevant factors to see whether that would be a substantial burden, an undue hardship on the governmental entity. This is you can adopt a policy. In fact, most cities and towns already have policies that talk about the grievances and what an employee must do to file a grievance and what appeal rights there are. My recommendation would be to look at this specific law and see what you need to do to change in your policy to make sure that you have the broadest ability to respond to these requests and identifying exactly what they have to do and what they to be able to have a request honored. There is a private right of action, just so you're aware. There are a few requirements there that you can look at as well. Let's see, I see Dennis Marker. Many professional organizations have codes of ethics. If someone espouses those, does that make it a religious or conscious belief? Likely yes, but I would need to do some case research to see exactly what those code of ethics are. It can be quite broad, frankly, and so I would say yes initially, but without further information, I couldn't give you an exact answer. But know that the religious or conscious belief is interpreted quite broadly. So the next section here is medical cannabis and drugs. This is Senator Escamilla and Representative Ward. The overriding purpose behind this was to make sure that governmental entities treated medical cannabis users and medical cannabis card holders the same as others that are using legally controlled substances or have a prescription for those as well. And let me first get into the definition of adverse employment action, because it leads into our next slide, is that means any sort of dismissal, suspension, reduction in compensation, failure to promote, or threatening any of those. So what this does is, before any adverse action of a person who tests positive for cannabis, or if they are a card holder, you have to have a policy that is comprehensive in nature and of when the employer can take that adverse action. And make sure that that policy doesn't treat medical cannabis or a card holder any different than a controlled substance user or a prescription holder. So it was made clear in one of the hearings that around the floor, Representative Ward made clear that if you've got a policy that restricts in a certain way medical cannabis, and you also have that for a controlled substance prescription, then that's okay, so long as they are treated equally. And so that's the overriding policy behind that. Before any action is taken solely because the employee is a cannabis card holder or a prescription holder of controlled substances, they've got to first consult with their city attorney if they have one or contracted with one, and they've got to obtain approval from the mayor. There was the circumstances behind this was to make sure that there weren't any violations of this law or any violations under the law that would that this adverse action would violate that law. And so this was there were a lot more stringent requirements. This was the compromise. It used to say taking away all state funding if a city is found in violation. And so we were able to change it to, look, if you're going to take adverse action, then talk to someone legally trained and someone and get approval from the mayor. So that was kind of a middle ground in the negotiations. The adverse action requirement, though, does not apply when doing so would violate any sort of provisions in federal grant money, security clearance, or other federal background determination. It also, and this is probably a more important one for everyone else, is employee's position is dependent on a license or peace officer certification that is subject to federal regulations. So be aware of that. Just so you know, though, that the exceptions that I just named, the federal funds or any of the federal regulations, license, you still have to consult with the city attorney or approve through the mayor, even if those other exceptions apply. If you are firing someone or taking adverse action on them for being a card holder. So those exceptions don't apply to that second requirement there, that you talk to the city attorney and approve through the mayor if you're solely taking that adverse action because they're a cannabis card holder or a prescription holder of controlled substances. The other drug bill was HB 411 that you should be aware of. This essentially allows, there was some unclarity, there wasn't clear direction on whether governments could use both oral drug tests and urine tests, or whether they had to only use urine tests. So this permits government entities to use oral drug tests. One of the cities had brought this up to Representative Molloy, and so that's why he ran this. It does say that you've got to do, you have to adopt a written policy or ordinance before you're going to drug test an employee, a volunteer, or a prospective employee. So make sure that they've got that written policy and that you have that and that's solidified. The next one is data privacy. Although there's only one here, HB 491, it is large and it is extensive. We are still working with the group that ran this bill and the Representative Jefferson Moss and Senator Collimore to see how we can better implement this bill. It covers a lot of things, and this will be a major thing that affects your city, frankly. We are still trying to, again, work with the sponsors on this and see if we can get it to a better place by next year. But this is, let me go over some of the high level points. Just want to make sure. Okay. The first is that if there are provisions in GRAMA that correlate with the provisions in HB 491, then the provisions in GRAMA will control over Part 4. We will be coming out with a white paper to see, to compare those different things, to see, you know, what GRAMA would control in this situation and what would Part 4 control. There are differences, but there are similarities with what is required. And so we just haven't got that white paper out yet because it's just, it is enormous. So all of the cities and towns will have to implement a privacy program, which is defined as policies, practices, procedures for processing personal data before May 1, 2025. The rest of the bill, though, for the most part, is effective May 1, 2024. So don't let this fool you. This is just the privacy program, but everything else will require you to implement by May 1, 2024. This personal data definition is extremely broad. Information that is linked or can be reasonably linked to an identified individual or an identifiable individual. Pretty much, at least in my mind, anything that you collect that related to an individual is pretty much personal data. So that's what we're talking about here. And so that's why it's so broad in its interpretation, is because everything revolves around that definition of personal data. There will need to be an annual report sent to the state. There needs to be an annual privacy training and 30 days after start of employment. This is something to be aware of, that if you have contracts that have personal data within them, or that they do collect personal data, you will want to make sure that there's a provision in all of the contracts that that says that contractors are bound by Part 4 in the same way that governmental entities are bound. So that goes for any renewals or any contracts entered into after May 1, 2024. So just be aware of that on any contract renewals. There also has to be a personal data request notice when requesting or collecting personal data. It has to include those things there: reasons for the request, what you're going to do with it, where it's going to go, how's it going to be categorized. And that request notice has to be on the actual form that is collecting that data, a QR code that links to an electronic version of that notice, or in a prominent place where the government entity collects the personal data. So look at your forms. Make sure that they have all of those qualifications in each of those forms, or that they point to an electronic version of that notice of how you're going to use that personal data. The last part of this that I wanted to go over is that it establishes a process for someone to amend the personal data after it's been collected by the government entity, but it does not require the government entity to accept that requested amendment. So all you have to do is create the process and have it written down, and there has to be a specific process to that. And then data breaches, there are requirements of when an affected person receives that notice that their personal data may have been jeopardized, but only after the governmental entity determines the scope of the breach and is able to restore the affected system enough to where that notice would not affect anything that law enforcement or others are trying to do. So the notice is in there. It also has stringent requirements that you should be aware of that we won't go into specifically today. We've got, this is on retirement. There are two bills, SB 34, Utah Retirement System Revisions, and HB 251, Post-Retirement Reemployment Restrictions Amendments. And the first of these, SB 34, makes sure that any URS participating employers are maintaining the records for URS, including any of the reporting, the contribution amounts, the certification. And if we fail to do that, to fully comply with those requirements, it adds a penalty of an amount not to exceed 50% of the participating employer's total contributions for the time period of the error. That could be a lot. So you need to make sure that you're keeping good records and that you're following the requirements there. HB 251, I am going to give this over to Carson.
Thanks, Jared. A little bit of background on this. This has been a multi-year effort, even predating the sponsor to a degree, where several legislators have really wanted to increase the number of public employees available, the overall labor pool, by creating reemployment policies to make it a little bit easier. One of the key areas here is that cooling off period, where under current law, you have to wait a year before going back to work for a public entity. This bill, again, is a product of a lot of stakeholder work, and I really want to applaud the bill sponsor for finding a solution that could kind of thread the needle and has kind of been able to sidestep a lot of the contradiction and some of the challenges we've had over the last couple of years. So what this bill does is it creates a second track to reemployment. It does not affect the current process. So if you have employees who are retiring and looking to be reemployed at some point, they could take both options. Now, I emphasize that because there are some potential drawbacks to be aware of if you are an employee or if you have employees who are looking at doing this. First, if you go through the shortening cooling off period, it's 60 days for public safety and 90 days for all other public employees. So that's a shortened period. That's great. You can get back to work sooner and collect your pension while you're working. However, there is a reduction to the benefits you're receiving. Namely, for public safety, it's a 15% reduction. For all other employees, that's 20%. So again, in certain situations, this works, and I think could be a cool tool. However, your employees, if they're looking at doing this, just need to be aware of those reductions. Their cost of living adjustment is also frozen just for the duration of that reemployment. So once they finally retire and they're not reemployed anymore, neither the reduction or the COLA freeze continue to apply. So they'll collect benefits as normal. And then one other note, if you are an employer who chooses to hire these employees, there will be an additional, you'll pay a higher rate for them to the Utah retirement systems. So again, optional for both employees, optional for employers. It doesn't require you to make any changes, but gives everybody kind of a new new tool for recruiting talent or for re-entering the workforce. So if you have any questions, we'll be doing a white paper on this with more details. I believe URS will be publishing some resources on this as well. So keep an eye out for those. And yeah, again, this has been a collaborative effort, years in the making. So we're excited to see something that kind of bridges that gap.
Carson, there's a question.
Yeah. So Dennis, that's an excellent question. The truth of the matter is we don't know exactly what the total impact will be. So in the fiscal note, URS was trying to budget it to be the total impact. So it really will definitively be revenue neutral or cost neutral for everybody else. If it turns out that the unfunded liability is lower or higher, we can go back and look at it in the future. But it really is just trying to share the costs among everybody who's participating, so that employees will actually want to use the tool, and so that employers aren't disproportionately burdened. It's just trying to balance that out.
Thank you, Carson. The next subsection of bills we're going to go over is employee-related matters, and that would relate to specific employee issues or topics coming up. The first one that we're going to talk about is Representative Birkeland's HB 257, sex-based designations for privacy, anti-bullying, and women's opportunities. I want to make an initial distinction that everyone should be aware of, is that although this bill went through many revisions and conversations, where it ended up was that this is about public school sex designated restrooms and city sex designated changing rooms. So this does not affect city sex designated restrooms or bathrooms that only has a toilet without a changing room attached. Changing rooms under that law is dressing rooms, fitting rooms, locker rooms, shower rooms, or if it's connected to a restroom, any of the above that's attached to a restroom. What this does is it prohibits individuals from accessing sex-designated changing rooms that are open to the public unless the individual's sex at birth corresponds with the sex designation of the changing room, or if that individual has legally amended their birth certificate to correspond with the sex designation of the changing room, and that they've actually had the primary sex characteristic surgery. There are some exceptions that you should also be aware of, that if it's just a city facility sex designated bathroom, like I just talked about, employee bathrooms, because they are not open to the public, generally will not be included under this law and under the restrictions for this law. If you've got a minor child that needs assistance, or someone that is dependent upon an adult or a caretaker, that would also be an exception. Any police, fire, EMS acting in that capacity, or any healthcare facility services. And it also includes janitors being able to go into the changing room. So those are the exclusions for that law. The city is required to call law enforcement if they receive a complaint or an allegation that someone's breaking the law. So please train your employees to not take action themselves, but to call law enforcement and have them handle that, and to train your law enforcement exactly what those provisions are in that law. It also does require us to adopt a privacy compliance plan that addresses compliance under the law. When discussing new construction, if you're doing new construction, most new construction has a at least one single occupant facility. But if you are doing that, make sure that it does, because that's required under this new law. And the existing bathrooms or changing rooms, all you have to do is consider the feasibility of retrofitting or remodeling to include those features. We were able to get this in there to where we negotiated with the sponsor saying, well, we don't want to be required to actually go and retrofit every single changing room or bathroom that we have. So she reduced that down to just considering the feasibility. And so that's all you need to do. And I would just document how you consider the feasibility of retrofitting any currently existing changing rooms or bathrooms. The penalty for violating this law is a fine of up to $10,000 per day on the city for violating and allowing this for someone to enter a changing room that is not corresponding to their sex at birth. There is protection for enforcing it, though, that the state will indemnify you, hold you harmless if the insurance policies don't cover it and arise because you are enforcing specifically this law. So what was quite a change in practice where this bill started. I think that practically speaking, it ended up we were able to get it to a place where it was at least manageable to implement and make sure that it was we were able to know what we should do if situations arise. The next bill is HB 55, again, Representative Birkeland, Employment Confidentiality Amendments. This is discussing where it discusses non-disclosure clauses and non-disparagement clauses. One is disclosing or discussing when there has been an allegation or sexual assault, sexual harassment, or allegations of sexual harassment. And it prohibits the city from preventing that employee that made the allegation from disclosing or discussing it. And it also prohibits an employee from making negative statements about that employer related to the allegations of sexual assault or sexual harassment. This is a really odd one because it's retroactive back to January 1, 2023. We are still looking at what that means for any of the employment settlement agreements that you've entered into after that time. And you want to make sure that you look at this very closely. If you do have provisions in your settlement agreements or separation agreements that have clauses like this in them. So it restricts those prohibitions of both non-disparagement and non-disclosure from being in a employment contract. As a condition of employment, you have to enter into this. That's prohibited. It's considered void and unenforceable. Once that employment has begun, then you can't take retaliation for someone that makes an allegation or refuses to enter into a confidentiality clause or employment contract. If you do put a non-disparagement clause or a non-disclosure clause in an employment contract, they have a 3 business day cooling off period where even though they've signed the settlement agreement or separation agreement with that confidentiality clause, they can revoke that and be released from the obligations of that separation agreement. So while it's not illegal to put these provisions in contracts, they just merely are unenforceable. So, and unless it's basically useless to try to enforce a settlement agreement because you will be liable for all the costs and attorney's fees to enforce it. Even for if you prevail, you still have to pay the other side's costs and attorney's fees, and you aren't entitled to any monetary damages resulting from a breach of that agreement. Don't put those in your separation agreements. It does not prohibit, though, a confidentiality clause that prohibits the disclosure of a settlement amount. It also, if the employee requests it, you can prohibit a clause that includes facts that could reasonably lead to the identification of the employee. You can also have a non-compete clause in there, which I don't know how that would even work in relation to the government. Trade secrets, other confidential proprietary information, all of that can be included. So this is more than just governmental entities. This is everybody. So one thing consider is a negative statement about an employer, which is permitted, is not the same thing as a knowingly false statement or reckless disregard for truth. So an employee can't just go and slander and make all sorts of accusations that are not true, knowing that they're not true. Or haven't done the background and the work to know whether they're true. They can make a negative statement about the employer, but it doesn't mean that they can go and slander the employer, your city. There is an unintended consequence of the legislation. It was a language error. That, just so you're aware, more than anything else, it defines sexual harassment in the law as discrimination on the basis of race, color, religion, sex, and national origin. So while this is what the law technically says, I think it would only be enforced as it relates to discrimination on the basis of sex. So, but I just wanted you to be aware of that. The next one applies to those that have public employees, legislators who work for the state, and that essentially you can't interfere with them taking unpaid leave or retaliate against them for taking unpaid leave on days of the session or other required training meetings. There is an exception for municipalities, though, and that is if and I've underlined this because this is important, the legislative body determines that complying with above would cause a significant difficulty or expense, depending on what the size of your city is, the financial resources, etc. Also, if you do have an agreement with the state legislator who works for your city, then that would override this particular law. The next one, HB 261. This is the Equal Opportunity Initiatives, otherwise known as DEI. And this prohibits any sort of statement or document that would require an individual to articulate the individual's position, view, contribution, effort, or experience relating to a program initiative that promotes differential treatment based on an individual's race, color, ethnicity, sex, sexual orientation, national origin, religion, or gender. There's a whole host of prohibited trainings that are required trainings that are prohibited. And I didn't want to go through each of them here, but there's a long list of those. So a lot of them are relating to schools, but some do apply to government entities. There are exclusions based on federal grants or any compliance with federal law, other state laws. Discrimination and harassment trainings are excluded, and any sort of position where you would require someone to have a certain race, color, ethnicity, sex, sexual orientation, bona fide occupational qualification for that specific position. The next part of that is social media policies. This is one that we just wanted to bring to your attention. It was not a bill, but it was a recent case that was passed, or that was decided this month, and I believe you say it, Lind v. Freed. There was, to give you a little bit of background on this, there was a city manager who had a personal account. He occasionally posted city-related information or announcements on that page, and but he started to have an individual post or respond to his posts that were derogatory or, as he claims, stupid, and he eventually blocked them completely, and that's when he was sued for prohibiting his right to free speech. The First Amendment only applies to government restriction on free speech, not on private action. So that's what this court, that's what the court focused on, and came down with this standard that a public official's social media activity constitutes state action under the law only if the official, one, possessed actual authority. So not just that they appeared to have that authority, but they actually did have that authority, whether it be through a job description, whether it be through specific authority to, hey, I need you to go and post this for our city or town. And then second of all, they have to actually purport to exercise that authority when they're speaking on social media. So for example, if someone has the authority to post notices of road closures, that doesn't also mean that just because they receive that authority on that they can speak on all other, and that they have the authority to speak on all other topics related to the government, new hires or events that are going on, or a public hearing, any of that. So the word to the wise is be deliberate in what authority you give in your job descriptions, and also make sure that you've got good social media policies. There's a white paper on this coming soon as well. The next and last, let's see, we're running up on time, but this is the last section, is school safety. This was run by Representative Wilcox and Senator Ibsen. It does modify the International Fire Code and requires building inspectors to coordinate with the county security chief to ensure compliance before issuing a C of O for a school. It also applies to law enforcement agencies with a school resource officer unit. There was a lot of conversation and negotiation on this bill. And we got to a point where I believe the chiefs of police were in a position that we weren't opposed to it. And so that's kind of the direction of this bill. It does require those with a school resource officer to do certain things, develop a policy that indicates the following, and then also provides regulations concerning school guardians and when and how and for what purposes they can carry and use a gun within a school. Training is required. And there are others that can contract as security for the schools as well. It's 85 pages, so it's a lot of fun. So that is the conclusion of our spring training for the general government.